Before we get into today's episode, I'd like to give a bit of a disclaimer and I guess an apology. You might hear a little bit of background noise intermittently throughout the episode because I was recording it on or around July 4th. Speaking of which, I hope everybody had a good Independence Day. But yeah, people were lighting off fireworks outside, and I hoped that that would be sort of to a minimum at the time of day that I was recording and didn't really hear them while I was recording. But while editing, I noticed a few. So apologies if that bothers anybody. But with that said, we can get into the episode. Welcome to episode 38 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Chevron USA versus Plaquemines Parish. The case was decided April 17th, 2026. And as always, we'll begin with the syllabus. The Federal Officer Removal Statute, 28 U.S.C. Section 1442A1, authorizes removal of state court suits against federal officers or persons acting under them for or relating to any act under color of such office. This case concerns whether, for purposes of the statute, a state court environmental suit challenging Chevron's crude oil production during the Second World War is for or relating to Chevron's wartime refining of crude oil into aviation gasoline for the U.S. military. In 1978, Louisiana enacted the State and Local Coastal Resources Management Act, which prohibited certain uses of Louisiana's coastal zone, including oil production, without a permit. The act exempted uses legally commenced before 1980. In 2013, Plaquemines Parish and other parishes filed 42 state court suits against oil and gas companies under the act. They alleged that the companies lacked permits and that some uses, although initiated before 1980, were illegally commenced and therefore not covered by the exemption. An expert report filed by the parish made clear that it intended to challenge certain defendants' crude oil production during the Second World War. The report alleged that Chevron failed to use steel tanks instead of earthen pits, should not have used vertical drilling methods, and failed to equip fields with sufficient roads, using canals instead. Chevron removed the suit to federal court under the Federal Officer Removal Statute, arguing that the suit related to its contractual duties to refine crude oil into avgas for the military during the war. The district court rejected this argument and granted the parish's motion to remand to state court. The Fifth Circuit affirmed, agreeing that Chevron had acted under a federal officer as a military contractor, but concluding that the suit was not for or relating to those acts because Chevron's refining contract did not specify how to acquire crude oil. Judge Oldham dissented, reasoning that crude oil was indispensable to avgas such that its production necessarily related to Chevron's performance of its federal avgas refining duties. Held, Chevron has plausibly alleged a close relationship between its challenged crude oil production and the performance of its federal avgas refining duties, not a tenuous, remote, or peripheral one, and has therefore satisfied the relating to requirement of the Federal Officer Removal Statute. Part A. The phrase relating to sweeps broadly, meaning to stand in some relation, to have bearing or concern, to pertain, refer, to bring into association with or connection with. One thing can relate to another even if the connection is indirect, even if it was not specifically designed to affect it, and even without a strict causal relationship. Accordingly, a removing defendant need not show that his federal duties specifically required or strictly caused the challenged conduct. The ordinary meaning of relating to, however, is not so broad that it is meaningless. The ordinary meaning requires a connection that is not tenuous, remote, or peripheral. Ordinary readers would not understand the Federal Officer Removal Statute to reach all suits with any attenuated connection to federal duties. Part B. Chevron's suit relates to the performance of federal duties because Chevron has plausibly alleged a close relationship between its challenged conduct and the performance of its federal duties. This suit implicates Chevron's wartime efforts to produce and supply avgas's essential feedstock, so it is closely connected to Chevron's wartime avgas refining for the military. Much of the crude oil that Chevron produced in Plaquemines Parish was ultimately used for its own avgas refining, and the suit challenges Chevron's actions that allowed it to increase its production of crude oil during wartime. The parish's report alleged that Chevron's use of the coastal zone had been illegally commenced because of its reliance on vertical drilling methods, canals, and earthen pits, but using vertical drilling methods maximized crude oil production. Using canals saved time and materials, resulting in more timely oil production, and using earthen pits complied with the government's directive to preserve steel. The government emphasized the importance of increasing Chevron's crude oil production to support avgas refining as part of the war effort, and it identified the oil field at issue as critical to the war program because it produced a preferential kind of crude oil for refining avgas. In this all-hands-on-deck wartime context, Chevron needed to produce more crude oil as quickly as possible to facilitate more avgas refining, including its own. Part C. The court disagrees with the Fifth Circuit's two main reasons for ruling to the contrary. First, the Fifth Circuit reasoned that Chevron's refining contract did not specify how to obtain or produce crude oil, so Chevron's crude oil production was unrelated to the performance of its federal refining duties. But the ordinary meaning of relating to does not require the defendant to show that his federal duties specifically invited his challenged conduct. Chevron's contract did not have to expressly direct or invite Chevron's crude oil production for that conduct to relate to its avgas refining. Second, the Fifth Circuit reasoned that the government's allocation of crude oil to refineries severed any relationship between producing and refining. But an act can relate to its consequences even when the causal chain includes actions by intermediaries. Producing crude oil relates to refining it into avgas, even if the government acted as an intermediary allocating the crude oil to refineries. Part D. The court also disagrees with Louisiana's argument that the removal statute requires that the defendant was acting under a federal officer in taking the specific actions challenged in the suit. This theory is not consistent with the statutory text, which permits removal of suits against officers or their agents for acts that were not done under color of their offices, so long as the suits relate to such acts. Louisiana's interpretation would leave the relating to requirement with little, if any, independent function, impermissibly conflating the acting under and for or relating to elements of the federal officer removal test. Justice Thomas delivered the opinion of the court in which Chief Justice Roberts and Justices Sotomayor, Kagan, Gorsuch, Kavanaugh, and Barrett joined. Congress has long authorized federal officers and their agents to remove suits brought against them in state court to federal court. The federal officer removal statute authorizes an officer or person acting under that officer to remove state suits for or relating to any act under color of such office. In this case, Chevron USA Inc. invoked the statute to remove to federal court an environmental suit brought against it in Louisiana State Court. Chevron argued that the suit was removable because it implicates Chevron's crude oil production during the Second World War, when Chevron also refined crude oil into aviation gasoline for the U.S. military. No party disputes that Chevron acted under federal officers when it performed its refining duties. We thus decide only whether this suit, which implicates Chevron's wartime production of crude oil, relates to Chevron's wartime aviation gasoline refining for the military. We hold that it does. Part 1, Section A. To protect the federal government from state court interference with its operations, Congress has given federal courts jurisdiction over some suits against federal officers or those acting under them. The current federal officer removal statute traces its lineage to the Force Bill of 1833, which Congress passed to enable federal customs officials to remove suits to federal courts after South Carolina began prosecuting them for enforcing federal law. Over the next 200 years, Congress expanded the scope of federal officer removal beyond suits against custom officials. Today, defendants may remove to federal court any, quote, civil action or criminal prosecution that is commenced in a state court and that is against or directed to the United States or any agency thereof, or any officer or any person acting under that officer of the United States or of any agency thereof, for or relating to any act under color of such office. End quote. 28 U.S.C. Section 1442A1. Under the Federal Officer Removal Statute, a removing defendant must satisfy three requirements. First, the removing defendant must be the United States, a federal agency, a federal officer, or a person acting under a federal officer, such as certain private parties hired to assist federal officers. Second, the suit must be for or relating to any act under color of such office. Third, the removing defendant must assert a colorable federal defense. This case concerns the second requirement. Section B. When the United States entered the Second World War, aviation gasoline, or avgas, became critical for the military. The war spurred a race to gain mastery of the skies. Success in the air required high-octane avgas, a superfuel for combat aircraft that helped produce more speed, more power, and quicker takeoff. Avgas refining therefore had to keep pace with the astonishing expansion of aerial activity during the war. In June 1940, the U.S. military used about 4,000 barrels of avgas per day, while American industry could refine 30,000 to 40,000 barrels per day. By 1944, at the height of U.S. involvement in the war, the U.S. military exceeded 636,000 barrels per day. President Franklin D. Roosevelt created the Petroleum Administration for War, PAW, to ensure that the United States would have enough fuel to win the war. The PAW oversaw the entire oil industry, from production to transportation to refinement. Within 2 weeks after the attack on Pearl Harbor, the PAW issued a directive for the production of 100-octane aviation gasoline to be greatly increased. The message was clear. Forget economic considerations, forget anything except getting out more and more 100-octane avgas as quickly as you can. With the PAW's assistance, the federal government, through the Defense Supplies Corporation, contracted with dozens of avgas refineries to secure avgas for the military. The government entered an avgas refining contract with a predecessor of Chevron, the Texas company. Footnote 1. All agree that as Chevron's corporate predecessor, the Texas company's acts were Chevron's acts for purposes of this case. We thus refer to it as Chevron. Carrying on. In its contract with the government, Chevron agreed to work day and night to quadruple its avgas refining capacity at its Texas refinery. It agreed that the government could request that it buy avgas components, including crude oil, from other firms. And it agreed that the government could at any time purchase all of Chevron's excess avgas. The government knew that to refine crude oil into avgas, Chevron needed crude oil. The government's contract with Chevron adjusted the price of avgas based on the cost of obtaining crude oil. The PAW allocated crude oil to specific refiners to maximize output, and the PAW required production methods that increased crude oil production, such as vertical drilling. At the same time, Chevron produced crude oil in Plaquemines Parish, Louisiana, including in 2 fields relevant to this case, the Delacroix Island and Delta Duck Club fields. Some of the crude oil produced in both fields went to the Texas refinery at which Chevron refined crude oil into avgas for the military during the war. In 1942, Chevron was refining 4,000 barrels of crude oil per day from fields in Plaquemines Parish. Section C. In 1978, Louisiana enacted the State and Local Coastal Resources Management Act. The act established a new permitting program that took effect in 1980. It prohibits any uses of state concern of Louisiana's coastal zone, including oil production, unless the user first obtains a permit. But it exempts from its permitting requirement individual specific uses legally commenced or established prior to the effective date of the Coastal Use Permit Program. In 2013, Plaquemines Parish, along with other parishes, filed 42 state court suits against oil and gas companies under the Act. The parishes alleged that the companies lacked permits for their uses of the coastal zone, and that some of these uses, although initiated before 1980, were illegally commenced and not covered by the Act's exemption for uses that commenced before 1980. The state of Louisiana and its Department of Energy and Natural Resources intervened in support of the parishes. Plaquemines Parish filed an expert report in one of these suits that made clear that it intended to challenge certain defendants' crude oil production during the Second World War. The report alleged that several uses had been illegally commenced during the war, making them violations which provide the basis for defendant liability. As to Chevron, the report identified production activities in the Delacroix Island field, where Chevron began drilling in 1941. Specifically, the report alleged that Chevron failed to use steel tanks instead of earthen pits. It alleged that Chevron should not have used vertical drilling methods, which allegedly harmed the environment more than alternative methods. And it alleged that Chevron failed to equip Delacroix Island with sufficient roads for transportation and instead primarily used canals. The report alleged that these production activities showed bad faith and failed to protect the marshland from contamination and excessive land losses, making Chevron subject to liability under the Act. All agree at this stage that this report reflects the parish's general theories of liability across the 42 suits. Several defendants removed the suits against them under the federal officer removal statute. The removal effort focused on the connection between these 1940s allegations and the defendants' 1940s federal contracts. Because the allegations concerned their 1940s crude oil production, the defendants argued that the suits related to their contractual duties to refine crude oil into avgas for the military at the same time. In this case, the parish's suit challenged Chevron's conduct at the Delta Duck Club field, where Chevron drilled during the war. Chevron removed on the theory that the suit alleged that Chevron illegally produced crude oil in the Delta Duck Club field while it simultaneously served as an avgas refiner for the military. The parish's state court complaint, like its expert report in the parallel case, alleged that Chevron's use of the coastal zone had been illegally commenced prior to the effective date of the Act, citing its crude oil production processes, use of earthen pits, and dredging of canals. Chevron's notice of removal thus argued that the complaint, alongside the parish's report, showed that the parish would target acts related to its performance of federal duties during the war. The district court rejected this argument and granted the parish's motion to remand to state court. The Fifth Circuit affirmed. The court agreed with Chevron that it had acted under a federal officer because it refined crude oil into avgas as a military contractor. But the Fifth Circuit concluded that the suit was not for or relating to those acts. It agreed that the complaint, when read in conjunction with the expert report, targeted crude oil production activities during the war. Nonetheless, it concluded that this suit, despite challenging Chevron's crude oil production, did not relate to the performance of Chevron's avgas refining contract because the contract did not specify how to acquire crude oil. Judge Oldham dissented. He reasoned that crude oil was indispensable to avgas, such that its production necessarily related to Chevron's performance of its federal avgas refining duties. We granted Chevron's petition for a writ of certiorari. Part 2. We address whether this suit, which implicates Chevron's wartime production of crude oil, is for or relating to Chevron's wartime refining of crude oil into avgas for the military. Footnote 2. The Fifth Circuit held that Chevron satisfied the first requirement of the removal statute because it acted under a federal officer when it refined crude oil into avgas for the military pursuant to a federal contract. No party disputes that Chevron acted under a federal officer in that capacity. We assume, without deciding, that it did. Carrying on. Chevron's wartime crude oil production was closely connected to its wartime avgas refining, so the parish's suit challenging that crude oil production relates to that refining. Section A. The phrase relating to sweeps broadly. It means to stand in some relation, to have bearing or concern, to pertain, refer, to bring into association with or connection with. One thing can relate to another even if the connection is indirect. One thing can relate to another even if it was not specifically designed to affect it. And one thing can relate to another even without a strict causal relationship. Accordingly, a removing defendant need not show that his federal duties specifically required or strictly caused the challenged conduct. Footnote 3. Congress only recently adopted the relating to statutory language. Before 2011, the statute required that the suit be for an act under color of office. This court had interpreted that language to require the removing defendant to show a nexus, a causal connection between the charged conduct and the asserted federal authority. In 2011, Congress broadened the statute by authorizing removal of suits for or relating to an act under color of office. Carrying on. The ordinary meaning of relating to, however, is not so broad that it is meaningless. To be sure, in a literalist sense, everything is related to everything else. But generally, in statutory interpretation, it is the ordinary, not literalist meaning that is the better one. The ordinary understanding of relating to requires a connection that is not tenuous, remote, or peripheral. Ordinary readers would not understand the statement that someone is related to Joe to refer to a mutual tie to Adam and Eve, nor would they understand the fluttering of a butterfly's wings to relate to next week's weather. Footnote 4. This is just a citation to a description of the butterfly effect, so I'm not going to read it out. Carrying on. And in this context, they would not understand the federal officer removal statute to reach all suits with any attenuated connection to federal duties. For instance, the D.C. Circuit has held that a false advertising suit targeting an oil company's statements to consumers about the future effects of fossil fuels on climate change did not relate to its decades earlier production for the government. Section B. Chevron's case fits comfortably within the ordinary meaning of a suit relating to the performance of federal duties. Chevron has plausibly alleged a close relationship between its challenged conduct and the performance of its federal duties, not a tenuous, remote, or peripheral one. This suit implicates Chevron's wartime efforts to produce and supply avgas's essential feedstock, so it is closely connected to Chevron's wartime avgas refining for the military. Much of the crude oil that Chevron produced in the Delta Duck Club field was ultimately used for its own avgas refining, and as the Fifth Circuit assumed, and no party disputes, this suit will challenge Chevron's actions that allowed it to increase its production of crude oil in the Delta Duck Club field during wartime. The parish's report alleged that Chevron's use of the coastal zone had been illegally commenced because of its reliance on vertical drilling methods, canals, and earthen pits. But using vertical drilling methods maximized production of crude oil. Using canals instead of building roads saved time, materials, and manpower, resulting in more timely oil production. And using earthen pits complied with the PAW's directive to preserve steel. If Chevron had refrained from these actions and produced less crude oil as a result, its avgas refining for the military may have suffered. Moreover, the government emphasized the importance of increasing Chevron's crude oil production to support avgas refining as part of the war effort. The PAW identified Delta Duck Club as a critical field essential to the war program because it produced a preferential kind of crude oil for refining avgas. Under Chevron's refining contract, the government paid more for avgas when the price of obtaining crude oil increased. Meanwhile, the PAW required the development of plans to increase to a maximum the production of all grades of aviation gasoline in the shortest possible time, including by addressing the need for components such as crude oil. And the PAW's regulations required the vertical drilling methods challenged by the parish as part of its effort to provide adequate supplies of petroleum for military and other essential purposes. In this all-hands-on-deck wartime context, Chevron needed to produce more crude oil as quickly as possible to facilitate more avgas refining, including its own. Chevron has therefore satisfied the relating to requirement. This suit implicates acts by Chevron that are closely connected to the performance of its federal duties. Footnote 5. We do not resolve whether the defendants in the related cases can satisfy the for or relating to requirement. We also do not address the other requirements of federal officer removal. Carrying on. Section C. We disagree with the Fifth Circuit's two main reasons for ruling to the contrary. First, the Fifth Circuit reasoned that Chevron's refining contract did not specify how to obtain or produce crude oil, so Chevron's crude oil production was unrelated to the performance of its federal refining duties. But the ordinary meaning of relating to does not require the defendant to show that his federal duties specifically invited his challenged conduct. For example, we have held in the preemption context that a state law can relate to benefit plans even when the law was not specifically designed to affect such plans. Likewise, Chevron's contract did not have to expressly direct or invite Chevron's crude oil production for that contract to relate to its avgas refining. Second, the Fifth Circuit reasoned that the PAW's allocation of crude oil to refineries severed any relation between producing and refining. But as this court's decision in Morales illustrates, an act can relate to its consequences even when the causal chain includes actions by intermediaries. Morales concerned whether state rules for advertising related to airline rates and were therefore preempted by a federal statute. This court explained that if states restrict advertising, the market puts less pressure on airlines to price competitively. Thus, advertising rules relate to rates, even though advertising affects rates only through the acts of an intermediary, the consumer. Likewise, producing crude oil relates to refining it into avgas, even if the PAW acted as an intermediary allocating the crude oil to refineries. Section D. Finally, we disagree with Louisiana's argument that it should prevail on an alternative theory. On Louisiana's view, this case should not turn on the meaning of relating to at all. Instead, Louisiana argues, the removal statute requires that the defendant was acting under a federal officer in taking the specific actions challenged in the suit. Louisiana does not dispute that Chevron acted under a federal officer while engaged in avgas refining. But because Chevron did not produce crude oil pursuant to a federal contract, Louisiana reasons that the suit is not against a defendant acting under an officer. Louisiana's theory is not consistent with the statutory text. The statute permits the removal of state court suits against any officer or any person acting under that officer that are for or relating to any act under color of such office. It contemplates removal of suits against officers or their agents for acts that were not done under color of their offices, so long as the suits relate to such acts. Louisiana's interpretation would leave the relating to requirement with little, if any, independent function. As the Fifth Circuit explained, Louisiana's interpretation impermissibly conflates the distinct acting under and connected or associated with elements of the federal officer removal test. We generally do not read a statute in a way that makes part of it redundant. Part 3. The Fifth Circuit erred in concluding at this stage that the suit against Chevron was not for or relating to its performance of federal duties. Accordingly, we vacate the judgment of the Fifth Circuit and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Alito took no part in the decision of this case. Justice Jackson concurring in the judgment. The court correctly holds that the underlying lawsuit is for or relating to Chevron's acts done under color of federal office. But I disagree with the majority's conclusion that the federal officer removal statute's for or relating to language requires only an indirect relationship between the conduct targeted by the lawsuit and the asserted federal duties. In my view, the statute demands more. Understood in the context of its statutory and legislative history, Section 1442A1 requires a causal nexus between the targeted conduct and the federal duties, as I explained below. Chevron satisfies the causal nexus requirement on the facts presented here, so I agree that the Fifth Circuit's ruling must be vacated. I therefore respectfully concur only in the majority's judgment. Part 1, Section A. Since 1948, Congress has authorized federal officers and people acting under federal officers to remove lawsuits brought for any act under color of federal office. We interpreted the statutory language to require a causal connection between the charged conduct and asserted official authority. In other words, we held that the federal directive giving rise to the authority to the act must be a but-for cause of the conduct challenged by the lawsuit. Congress amended the federal officer removal statute in 2011, adding the or relating to language. The question the court answers today is what this addition means. Section B. In responding to this inquiry, the majority considers in isolation the ordinary meaning of the phrase relating to. Based on our case law interpreting that phrase in other contexts, the majority concludes that this language requires only an indirect relationship between the conduct alleged in the lawsuit and the asserted federal duties. Accordingly, in the majority's view, Congress's addition of or relating to jettisoned the causal nexus test in favor of a looser standard. I think the court should interpret the relating to addition primarily by determining what Congress intended to accomplish with this amendment. Indeed, the court's fundamental task in interpreting federal statutes is to give effect to Congress's intent, and the court faithfully discharges this duty when it considers all reliable evidence of Congress's intent, including statutory and legislative history. Here, the statutory and legislative history is clear. Congress did not set out to change the causal nexus requirement with its 2011 amendment. Rather, the relating to addition was motivated by a problem entirely separate from the causal nexus requirement. At the time of the amendment, 40 states had laws authorizing private parties to compel document production or depositions before they commenced a lawsuit. See Removal Clarification Act of 2010, hearing on H.R. 5281 before the Subcommittee on Courts and Competition Policy of the House Committee on the Judiciary. 111th Congress, 2nd Session. Footnote 1. The House hearings were for a predecessor bill proposed the year before the Removal Clarification Act was passed. The predecessor bill included the or relating to language that was ultimately enacted. Carrying on. Federal officers were sometimes the target of such pre-suit discovery proceedings. Courts were split, however, on whether federal officers could remove pre-suit discovery proceedings to federal court under Section 1442A1. Congress amended the federal officer removal statute to clarify that pre-suit discovery proceedings targeting federal officers were removable. Congress made substantive changes to that end. For example, it specifically stated that any proceeding in which a judicial order, including a subpoena for testimony or documents, is sought or issued was removable. Congress also made several conforming amendments. The addition of the or relating to language to Section 1442A1 was one of them. The addition of or relating to was not a substantive change. Section C. That the addition of or relating to was a conforming amendment is meaningful. Congress rarely changes the substance of a statute through mere conforming amendments. Such amendments are typically minor tweaks intended to harmonize or clarify amended statutory provisions. Thus, it would be passing strange to conclude that Congress made a radical but entirely implicit change to the standard for federal officer removal through a conforming amendment. And indeed, the legislative history here confirms that Congress did no such thing. It makes crystal clear that the Removal Clarification Act was not changing the underlying removal law, but was instead simply clarifying that Section 1442 would apply any time a legal demand is made on a federal officer for any act done under their official capacity. Moreover, the history establishes that Congress knew the removal law it was amending required a causal nexus. So, with full knowledge of the causal nexus test, Congress made only a conforming change. It did not alter the substantive requirements for removal. This is not to say that the or relating to language served no purpose. By adding it, Congress confirmed that subpoena enforcement and pre-suit discovery proceedings fall within the scope of Section 1442. The nature of pre-suit discovery proceedings necessitated such confirmation. Pre-suit discovery proceedings seek to get information, not to accuse the target of engaging in unlawful conduct. Thus, to describe a subpoena or deposition as being for unlawful conduct is factually inaccurate. If the statute permitted removal of only those proceedings that are for federally directed conduct, then arguably that statutory provision would not authorize removal of pre-suit discovery proceedings. But pre-suit discovery proceedings are related to a defendant's federally directed conduct. So, because the amended Section 1442 would now include proceedings that do not seek to impose civil liability or a criminal penalty on the federal officer, the statute allows removal not only in proceedings for acts under color of the federal office, but also in proceedings relating to such acts. In short, by adding or relating to, Congress confirmed that the substantive changes broadened the universe of acts that enable federal officers to remove to federal court. The amendment clarified that pre-suit discovery proceedings were squarely within the universe of acts that a federal officer could remove, but Congress did not intend to change any of the underlying removal requirements, including the causal nexus test. Part 2. Although the majority and I interpret the for or relating to requirement differently, we agree that the state lawsuit here satisfies this requirement. The lawsuit targets Chevron's crude oil production activities, and as the majority explains, Chevron's predecessor contracted with the federal government during the Second World War to produce aviation gasoline, avgas, a product refined from crude oil. Chevron used much of the crude oil it pumped from its Louisiana oil fields to refine into avgas during the war. This was no accident. The crude oil from Chevron's Louisiana fields was particularly well suited for refining into avgas, and the federal government pushed its refiners, including Chevron, to produce more and more avgas. This, in turn, demanded an ever-increasing supply of crude oil. Chevron therefore produced crude oil, at least in part, to meet the demands of its federal contracts, satisfying the causal nexus requirement. The Fifth Circuit erred in concluding that the removal statute's for or relating to requirement was not met under the circumstances presented here. It faulted Chevron for failing to identify a specific contractual directive pertaining to oil production. But Chevron's federal contracts can be a but-for cause of the challenged crude oil production without specifically directing that production. Because the Fifth Circuit's contractual directive demand goes a step further than even the causal nexus test, I agree with the majority that the Fifth Circuit's judgment must be vacated. And that is it for the opinions of the justices, so now we'll get into the opinions of the host. Yeah, I mean, this seems pretty straightforward to me. It was unanimous at least as to the judgment. Notably, Alito didn't take any part, so we don't know how he would have voted, but 8 of the justices agree that Chevron can remove to federal court, but one of the justices disagrees as to why. And yeah, I think the majority's reasoning is much better and almost certainly more correct than Jackson's. Jackson is once again doing this thing where, she and she alone, even alone among the other liberal justices, seems just determined to bring legislative history back into the mainstream, or at least, into the mainstream on the court. And yeah, even the other liberal justices don't seem to be really going with her on this. But yeah, her opinion relies pretty much exclusively on legislative history. And I mean, I've talked before about why I dislike legislative history, why I think the court rightly dislikes legislative history. She says, oh, well, our goal is to, enact the will of Congress, or adhere to the will of Congress, the intent of Congress. And in order to do that, we should be looking at all relevant, all reliable evidence of Congress's intent, including legislative history. And I think both of those premises are just wrong. The judiciary does not exist to enact the intent of Congress. I'm sure there's plenty of statements to that effect, plenty of statements of justices in the past who have, believed that to be their role, and plenty of statements by justices in the past that maybe imprecisely stated that as their goal. But yeah, I don't think that's the role of the judiciary at all. The role of the judiciary is to say what the law is, not to try and divine one cohesive intent of a body that's made of well over 500 people. The endeavor just kind of stumbles at the very beginning, or falters at the very beginning. The goal of divining, an intent of Congress is already just an impossible one. There is no single intent of Congress's. There, I mean, again, there's the intents of over 500 people that then wind up expressed in this law, this specific text that they settle on to codify into the law. And that text is the law, not whatever each of those 500 people might have intended when they wrote it down. Yeah, and then there's the other premise that legislative history is even a reliable indicator of the intent of Congress, or what Congress as a body is thinking. Because, I mean, what legislative history is just statements of Congress people. And I don't read most of the citations here, so you didn't, you, the listener, didn't hear this, but I saw this while I was reading. All of Jackson's citations, legislative historical citations, are just citations to statements by individual legislators. It's I'm sorry, I don't think statements by one of over 500 people, or even a small committee of over 500 people, is a reliable indicator of what those 500 people as a group, as an entity, insofar as they can have one intent, one collective intent. I don't think those individual statements are a reliable indicator of that collective intent, if it even exists. So yeah, I don't like legislative history. The court, by and large, doesn't like legislative history. Even the liberal justices don't seem as married to legislative history as Jackson is, and it frankly annoys me when she writes separately to kind of harp on it. But that's kind of my biases, I guess. If you're big on legislative history, I'm sure you love Jackson writing separately in the way that I often like Thomas writing separately. But yeah, so I'm very much with the majority on this. The text of the law says relating to. Relating to has this, ordinary meaning, and this meaning that the court has applied consistently in other contexts. It's the same meaning here, and if Congress actually intended something else, and it was supposed to be this inconsequential, almost nothing of a change that Jackson suggests it was, and they actually intended a causal nexus requirement, first of all, they could have said that, and they didn't. And second of all, they can still say it. So, Congress can fix the court's mistake if it made one. I don't think it made one here. And again, even if the court did interpret this law in a way that's out of accord with what the ratifying Congress was trying to do or intended the law to do, again, the law is the text, and the text is for or relating to. Relating to means a particular thing. If Congress misspoke, that's on Congress, that's not on the court. But anyway, that's enough of me rambling and ranting, mostly about just Jackson's judicial philosophy and how much I dislike it, and not so much actually about the legal merits of this case. But yeah, I don't know, the legal merits of this case seemed pretty straightforward and a little less interesting than ranting about legislative history, I guess. at least to me. Anyway, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we'll continue on through the Supreme Court's 2025 term. Until then.